All right, Mr. Hodge, would you resume the witness stand, please? All right, the records reflect that Mr. Roderic Hodge is on the witness stand undergoing cross-examination by Mr. Darden. Good afternoon, Mr. Hodge. Mr. Hodge, you're reminded, sir, that you were still under oath, and Mr. Darden, you may continue with your cross-examination.
Do you still have the documents from this morning, Mr. Hodge?
No, sir. I gave them back to your assistant.
At any event, do those
Ms.
documents...
Lewis. All right, Mr. Hodge, why don't you pull the microphone close to you there, please? Thank you.
Okay. Did you see the epithet indicated here in these documents?
No, sir.
Okay. You think it might be contained in some other document?
Rephrase the question.
At any event. Thank you, Mr. Hodge.
Mr. Cochran.
Thank you for your comment. Good afternoon, Mr. Hodge.
Sir.
Mr. Hodge, is there any doubt in your mind that in the month of January of 1987, Detective Fuhrman referred to you as a nigger?
Sir, there's no doubt in my mind whatsoever.
Is that something you'd forget?
Something you don't forget.
Now, Mr. Hodge, sir, with regard to this document that Mr. Darden showed you, did you get a chance to look this document over at lunchtime?
Yes, sir, I did.
And with regard to that document,
Or we'll
Document's
have
marked,
heard the
yeah.
question yet.
with regard to this document, may I approach you?
You may.
With regard to this document, it indicates that after your encounter with Mr.
Objection.
Fuhrman
Hearsay.
and the other...
Hearsay, Your Honor.
May I finish the question?
Finish the question.
After your encounter with Mr. Fuhrman and the other officers on that day, you went down and made a complaint for their behavior, isn't that correct?
That's correct, sir.
And I'd like to show you this document, which is, what's this people's, what, Your Honor?
This is 604.
I want you to take a look at 604. And first of all, you are Roderic T. Hodge, is that correct?
Yes, sir, that's correct.
And with regard to the type of complaint you rendered against these officers, do you see that? Do you see this box here under type of complaint?
What's the objection? Overruled.
You see the type of complaint?
Oh, yes, sir.
All right. Do you recall that you went down at some point after the contact with Mr. Fuhrman and the other officers and made this actual complaint?
There were a couple of times, yes, sir.
All right. Did you, in addition, did you go to West Los Angeles on some occasion?
Yes, sir.
Did you also go someplace else and make a complaint?
Yes, sir, I did.
And where'd you go to make that complaint?
Downtown location, what we refer to as the Parker Center.
All right. Did you go to Parker Center on the same date you went to West Los Angeles?
No, sir.
That was on a different date?
Yes, sir.
And why did you go to both locations to make complaints about the conduct of these officers?
Overruled.
My brother, who's a
Well,
law enforcement...
Hold on. You made 2 complaints, 2 places, both at West LA and downtown at Parker Center, correct?
Sir, I made 3 complaints.
3 complaints. Where else?
My brother advised me that West Los Angeles Police Department would not pursue...
Sustain.
Let me just go question by question, Your Honor. You have a brother in law enforcement?
Yes, sir, I do.
What kind of law enforcement was he in?
The Department of Corrections.
Did you have occasion to discuss with your brother, who was in law enforcement, whether or not you should make a complaint?
Yes, sir.
Did he give you some advice?
On many occasions.
And after you got this advice from your brother, who was in law enforcement, where did you go?
To the Parker Center.
And that was after you'd been to West Los Angeles?
That's correct.
And did you make a complaint at Parker Center?
Yes, sir.
You said you went a third place. Did you go some other place to make a complaint?
No, sir. I made 2 complaints at the West LA station and one at the Parker Center.
All right, so that was the third complaint?
That's correct.
All right. Now, with regard to these documents that Mr. Darden showed you, did you notice anything unusual about the pages? Did you look at the pages and look at the numbers of those pages?
Do you want to show him 604, the actual exhibit?
Sure, I'll be glad to, Your Honor.
All right, because we're talking about 2 different documents here.
Thank you. I want you to look at the last 2 pages of 604. See if there's anything unusual about the numbering of the pages there.
Yes, sir.
What'd you see? Tell the jury what you see there.
Well, it goes from page 6 to page 17.
You know what happened to pages 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16?
No, sir, I would have no idea.
Now, with regard to that document, look in the upper right-hand corner under the type of complaint that you made against these officers on January 13th, 1987. You see that?
Yes, sir.
And what does it say?
Objection.
Sustained.
I may want to approach this briefly, if I could, to show
All
the
right,
court
with
something.
court order, please.
Thank you.
Mr. Cochran.
Thank you, Your Honor. Now, Mr. Hodge, when you made these three complaints to the Los Angeles Police Department, did you include a complaint for discourtesy of the officers involved on that date, including Mr. Fuhrman?
Yes, I did.
When you included this complaint for discourtesy, did that include him calling you or saying, we told you we were going to get you, nigger?
Yes, sir, that's correct.
Now, you have not tried to profit from your involvement in this case in any way, have you?
No, sir, not at all.
Like, have you tried to stay away from publicity in connection with this?
As far away as possible, yes, sir.
Were you contacted by ABC News back in March of this year?
Yes, sir.
And did
Excuse me,
you?
excuse me, Mr. Cochran. Mr. Hodge, would you just pull the microphone a little closer, please? Thank you. Mr. Cochran.
Thank you. You were contacted by ABC News back in March of this year?
That's correct.
And you did not go on camera at that point, did you?
No, sir, I have not.
You haven't tried to sell your store to anyone, have you?
No, sir.
You came out here a week ago from Illinois because you were subpoenaed, is that right?
That's correct.
And as soon as you can, do you want to go back home?
Yes, sir.
Thank you very much for coming, sir.
Mr. Darden?
Have a safe trip home, sir.
Thank you, sir.
Thank you.
All right, Mr. Hodge, thank you very much, sir. And if you would return that document to Mr. Darden, please.
Yes, sir.
All right, thank you, counsel. All right, let me see counsel at the sidebar without the court board, please.
One stipulation is on the way down now.
I believe Mr. Neufeld has another stipulation.
All right, Mr. Neufeld, you have a stipulation that you've discussed with
Yes.
Ms.
With,
Clark and Mr.
Ms.
Darden.
Clark, yes. And the stipulation is, what number are we up to? Defense exhibit, Your Honor?
1369.
Okay,
All right, we'll
That-
mark the stipulation 1369.
yes, which is simply the sunrise and sunset times for Los Angeles, California, and in particular for the stipulation that on June 13th, 1994, the sun rose at 5:41 a.m. Pacific Daylight Time.
All right, and ladies and gentlemen, if you recollect, the stipulation is agreement between the attorneys as to certain facts, and you were to assume those facts to be true for the purposes of making your determinations in this case. All right, and Mr. Darden, you said that there's another stipulation on its way down?
Yes.
All right, ladies and gentlemen, while we await that stipulation to be brought down from upstairs, I am going to be excusing you in a few moments to be taken up to the larger lounge upstairs so you'll be a little more comfortable. There are a couple of more legal issues that I need to take up with you. And as you notice, I was having a conversation with the lawyers over at the sidebar without the court reporter just to discuss with him informally the scheduling for the remainder of the trial. And I anticipate on the basis of that discussion that the defense should be concluding the presentation of their case this week. So just a few more legal issues I need to resolve, and then we'll hopefully conclude that phase of the trial. So just to let you know, we are making progress. But I do have a few more legal issues I need to iron out before we get to you. But I anticipate we may have some additional testimony for you this afternoon.
Some modification and it's on the way down.
Okay.
The courier has already left. 18.
Be a better use of our time than to take our recess at this point, excuse the jury, and then launch into our issues. I'm sorry? Ms. Clark?
Thank you.
Okay. All right, then, as far as the jury is concerned, then we'll stand in recess. Remember my admonitions to you. As soon as we clear the courtroom with the jury, we'll reconvene. All right, thank you, counsel. The legal issues we need to resolve before we resume with and complete the defense case, correct?
Yes, Your Honor, I believe that is correct. If the court pleases, just as a matter of direction, I would ask the court to listen to Dean Uelmen first in order of our presentation, please.
All right, as to what issue, Mr. Uelmen?
This would be as to the suppression motion, Your Honor. And I also have an offer of proof with respect to the remaining testimony of Laura McKinney.
Well, let's take these things one thing at a time.
All right? Perhaps the offer of proof... It is our contention that in the cross-examination of Laura McKinney by Mr. Darden, the questioning with respect to discussions between Ms. McKinney and Detective Fuhrman with respect to cover-up opened the door to allow the jury to hear the portion of McKinney transcript number 1. Actually, this is not a taped transcript, but it would be page 41 of McKinney transcript number 1, in which there is a discussion of the departmental cover-up with respect to the performance of women within the department. It starts with Fuhrman. The second time the name Fuhrman appears on page 41 and goes down to the end of the page. We believe the door has also been opened to a discussion which appears in transcript number 11, beginning at page 19 and proceeding through page 26. This is a discussion between Ms. McKinney and Detective Fuhrman regarding how she could portray in her screenplay the cover-up that would be necessary where an officer is being investigated and needs to create the appearance of being one place rather than another, and Detective Fuhrman describes how logs can be falsified. Alternatively, if Your Honor will not allow us to play the tapes, we believe that Ms. McKinney could describe these conversations in terms of their general tenor. The exchange in tape number 11 that I'm talking about relates directly to Ms. McKinney's testimony and Mr. Darden's questions about the relationship between the men versus women theme of her screenplay and the topic of cover-ups. That is, the ability of male officers to cover up and of female officers not having the same ability to cover up their tracks.
All right, were you going to... All right, never mind. People, Mr. Darden.
I have an idea of what Mr. Uelmen is talking about, and I think we argued these issues this morning for the most part, and I would say objection on the same grounds as stated this morning. I would say that it is hearsay. That one, what number was it? Okay, and the number 11 proffer was one that was clearly fictional. And why do we have to go back there? Okay, the damage is done. I think the court understands what happened this morning with that particular witness, and we object.
All right, Mr. Uelmen.
With respect to the hearsay...
Wait, hold on, one second.
Judge, would the court ask counsel to read the information? Judge, would you... transcript number 1, pages 41 to 42. They don't relate directly to the issue counsel has attempted to raise at this point. They're irrelevant to that testimony, to Ms. McKinney's testimony as it related to cover-ups and women.
All right, Mr. Uelmen.
With respect to the hearsay issue, Your Honor, of course, these portions of the transcript are not offered for the truth of what is asserted. They are offered to demonstrate the nature of the conversation between Ms. McKinney and Detective Fuhrman. There was an attempt to portray the nature of these conversations in a false light through Mr. Darden's cross-examination. He was suggesting that Ms. McKinney was attempting to sensationalize this screenplay, that there was even allusions to a possible illicit relationship between Ms. McKinney and Detective Fuhrman. There was a suggestion that she was attempting to get Detective Fuhrman to portray the information that he was presenting to her in a dramatic and exploitative way, and we believe that the jury's entitled to see and to hear how these conversations took place, especially in the context of the question of cover-up that Mr. Darden alluded to, so the jury can see the context. And the context, as Your Honor knows, makes all the difference in the world in explaining how these conversations took place and what was actually going on between Laura McKinney and Detective Fuhrman.
All right. Thank you, counsel. All right. As to the second example first, the discussion within the context of the screenplay, the question being from Ms. McKinney as to how would a certain cover-up be portrayed for the purposes of the screenplay. That's clearly in the discussion of the creation of a fictional screenplay. As such, it's not relevant. Objection will be sustained. As to the issue of the department's cover-up of the performance of women as police officers, interesting topic, but not for this trial. The objection is likewise sustained on the basis of relevancy. All right, next issue.
The next issue, Your Honor, is the renewal of the defendant's motion to suppress.
All right.
And I think an appropriate place to begin is with the legal standard to be applied in terms of the impact of newly discovered evidence. And we believe that the leading case on this question is People versus Ramsey, cited in our brief at page 7, which quite clearly holds where additional evidence is presented, the findings of the magistrate, to the extent they are affected by the additional evidence, are not binding on the Superior Court. This allows the Superior Court to exercise its independent judgment on issues on which additional evidence is introduced. The additional evidence that we wish to introduce relates directly to the credibility of Detective Mark Fuhrman. And our position, quite simply, is that Your Honor, in considering this evidence, is not bound by whatever findings were made with respect to Detective Fuhrman's credibility in the municipal court, but that you are to exercise your independent judgment on the issue of his credibility. Now, the prosecution has contended that what we are offering with this additional proffer is simply evidence going to his general credibility. And I want to point out to the court the very clear relationship between the portions of the McKinney transcripts and tapes that we are proffering as new evidence on the credibility of Detective Fuhrman and the testimony that he presented on the motion to suppress. And I think it's fair to call the court's attention to the fact that there were only two detectives who testified on the motion to suppress, Detective Van Adder and Detective Fuhrman. And Your Honor will recall that in the context of a number of misrepresentations made by Detective Van Adder in the affidavit for the search warrant, this court made a finding that Detective Van Adder had a reckless disregard for the truth. So that the credibility of Detective Fuhrman becomes a very, very important aspect of the determination of the defendant's motion to suppress. Do we or should we put any faith in the testimony of Detective Fuhrman with respect to the circumstances that led up to the warrantless search of the defendant's premises on the morning of June 13th? Now, we have essentially, well, let me identify each of the issues where we believe the credibility of Detective Fuhrman is in issue. First of all, with respect to the justification for the entry to the premises. As Your Honor will recall, the explanation offered by the detectives for their trip from Bundy to Rockingham was that it was for purpose of making a notification. Mr. Simpson was not a suspect. Their reason for going to his residence was to notify him of the death of his former wife and to make arrangements for the care of his minor children who had been found in an upstairs bedroom at the Bundy scene. It was only after they arrived at the premises and a speck was found on the door of the Bronco above the handle to the driver's side door that the circumstances were transformed. And the officers determined that they had some sort of emergency that justified an immediate entry to the premises without a warrant. And of course, the discovery of that speck on the door was a discovery by Detective Fuhrman. It was Detective Fuhrman who testified he went by himself from where the officers were gathered at the gate to enter Mr. Simpson's premises, that he noticed that the Bronco was parked in a very haphazard manner, as he put it, that he went over and he made the discovery of the speck on the door. Now, in that context, it is significant that this is the same Detective Fuhrman who, in the context of the McKinney tapes and transcripts, offers the following comments. This is Miss McKinney, and I'm reading from her transcript number 1, pages 24 to 25. So if you ripped up his identification, you're not going to mention that you ripped it up, are you? And he answers, never. But that doesn't mean I didn't say I didn't. Nobody asked. And the interviewer, Miss McKinney, asks, how about if somebody asks? And Fuhrman says, well, then I won't. That's an investigation of a police report. When you say falsification of an arrest report, that's when somebody's walking down the street and I see him throw something, but I don't see what he throws. Then I go back where he threw something and there's a gun. Now, if you want to let that guy go, if you're a citizen, do you want that guy on the street or in jail? Obviously, you want him in jail, unless you're a jerk too. So the only way to put him in jail is for the policeman to say, I saw him throw that gun. Interviewer, Miss McKinney. Oh, identifying the action with the object? Fuhrman. Of course he threw it. What are the odds of going to a place where he threw something and having that be a gun? 10 million to 1, 30 million to 1. I don't know what the odds would be, but it's got to be astronomical. So if that's considered falsifying a report, and if some hype, says, whatever I shot 2 days ago, and you find a mark that looks like 3 days ago, pick the scab, squeeze it. Looks like serum's coming out, as if it were hours old. It's a hard find. You just can't find the mark because he's down. His eyes don't lie. That's not falsifying a report. That's putting a criminal in jail. That's being a policeman. Now, obviously, Detective Fuhrman's definition of being a policeman as including making up the facts that are necessary to put someone in jail once you've determined that person should be in jail is highly relevant to his testimony of finding the one iota of evidence that will justify or be offered as justification to make an immediate entry to Mr. Simpson's premises. And we believe it is highly relevant that in this example, he is discussing the manufacture of blood evidence. He is discussing scratching a scab to make fresh blood to provide an officer with probable cause to make an arrest. And he's saying, that's not falsifying a report, that's being a good cop. The second instance where the justification for the conduct of the officers on the morning of June 13th is questioned relates to the limited purpose for which they made entry to the premises. This supposed emergency that was created by the discovery of this speck on the car door meant that in addition to the purpose of locating Mr. Simpson and notifying him of the death of his former wife, making arrangements for the care of their children, we now add this new justification that there may be a victim on the premises, or there may be a perpetrator lurking on the premises. That is not a justification that includes searching for evidence. And what does Mr. Fuhrman do? Mr. Fuhrman goes to Cato Kalin's room, enters the room, interrogates Mr. Kalin, searches the room, searches Mr. Kalin's clothes, looks at the soles of Mr. Kalin's shoes, and does not ask him any questions about whether there are any potential victims on the premises. He simply asks about the thumps that Mr. Kalin reports hearing on the wall the night before. There's no follow-up questioning at all in terms of expressing any concern with respect to whether there are any victims or perpetrators lurking about. And in this context, I think it's important to remember that this is the same Detective Fuhrman who, in the context of his conversations with Miss McKinney, says, and now I'm quoting from pages 33 and 34 of that same transcript number 1, "So under what did you arrest him?" the interviewer asks. Fuhrman: "I didn't arrest him under anything, just took him to the station, ran him for prints, gave them to the detectives to compare with what they've got in the area. I'll probably arrest a criminal that way." And he's referring here from the prior context to an arrest that he had made himself just the night before. And the interviewer asks, "So you're allowed to just pick somebody up that you think doesn't belong in an area and arrest him?" And Fuhrman says, "I don't know." Interviewer: "Well, I mean, you did, so?" And Fuhrman says, "I don't know. I don't know what the Supreme Court or the Superior Court says, and I don't really give a shit. If I was pushed into saying why I did it, I'd say suspicion of burglary. I'd be able to correlate exactly what I said into reasonable cause for arrest. And the interviewer asks, but nobody usually crosses you, do they? Because they know if you're pushed, you're going to come up with something. And Fuhrman responds, well, my supervisor has confidence that I know what I'm doing, so they don't make beefs about it. This is obviously highly relevant to the conduct of Detective Fuhrman in essentially entering those premises to search for evidence and then making up a reason later to justify what he had done. The next example of the relevance of these newly discovered tapes relates to the question of the scope of the search activity that Detective Fuhrman then engaged in. Your Honor will recall that after Cato Kalin told him about the thumps on the wall, Detective Fuhrman told no one else about that. He didn't mention that to any of the other detectives. He simply said to Detective Van Adder, you ought to talk to this guy, and then went off by himself to the rear of the premises, where he was for approximately 15 minutes, according to his own testimony. And what's he doing back there? He says, I'm looking for a victim. I'm looking for the body of somebody that may have been injured. No basis whatsoever to assume that there would be any victim back there other than the thumps on the wall, and yet he didn't question either Kalin or Arnell Simpson about whether they heard cries from anyone back there, whether they heard any other noises back there. He goes back and he looks around for approximately 15 minutes, and then he takes the other detectives one at a time to show them what he allegedly discovered. Well, Your Honor, this is the same Mark Fuhrman who, in his conversations with Laura McKinney, and I am now quoting from tape number 3 at page 3, makes the following comments. Fuhrman, well, I really love being a policeman. McKinney, why do you love being a policeman? Fuhrman, when I can be a policeman. It's like my partner now. He's so hung up on the rules and stuff. I get pissed sometimes and go, you just don't even fucking understand. This job is not rules. This is a feeling. Fuck the rules. We'll make them up later. Well, there are rules about what kind of search activity a police officer can engage in without a search warrant. The activity of Detective Fuhrman on the morning of June 13th raises serious questions about whether he followed those rules. And the attitude exhibited in this exchange that is on tape in the McKinney tapes certainly raises a question that should be asked about Detective Fuhrman's understanding of the rules and limits on the kind of activity that he could engage in. The next issue relates to the role of Detective Fuhrman in the investigation of this case after he is taken off of the case at approximately 2:30 in the morning. Your Honor will recall that almost 3 hours after he is removed from the case, it is Detective Fuhrman who leads the other detectives from Bundy to the Rockingham residence of the defendant. It is Detective Fuhrman who finds the speck on the Bronco. It is Detective Fuhrman who then leads the detectives over the wall into the premises. And it is Detective Fuhrman who ultimately finds the glove. And with respect to all of this investigative activity, there are no notes, there are no logs, there are no reports. His testimony is, I stopped making any record of what I was doing as soon as I was taken off the case at approximately 2:30 in the morning. Perfect setup. No way to double check any of his activity in terms of what happened after he was relieved from the case. And, Your Honor, this is the same Detective Fuhrman who, in his exchange with Miss McKinney, and this is on the tape 6A, I'm reading from page 3 to page 4. This is embarrassing. This is Detective Fuhrman speaking. Then you go to court, and I'm the only one who knows how to testify. You have 5 officers on the case, and I'm the only one there that knows how to testify. The DA goes, yeah, but you were the 4th car, but would you testify? Yeah, but you did see, I saw it, don't worry about it. Yeah, I saw him do that. Yeah, I saw him do that. Yeah, okay, goodbye. Why do I have to do everything? That's what it is coming down to. I have to fight the guy, I have to catch the guy, I have to keep the guy's mouth shut at the station because they're not going to do it for a female. I can just walk by and go, shut up or I'm going to kick your face in. Now, the relevance of that, obviously, is that it's a pretty good description of what was going on the morning of June 13th. Detective Fuhrman had to do everything. And what he's saying in this exchange is doing everything means also providing whatever testimony is necessary regardless of what happened. We believe that the prior conduct of Detective Fuhrman is highly relevant to the credibility on the suppression issues. We're not talking about general credibility here. We are talking about a police officer who believes that lying to justify an arrest or a search is okay, that the end justifies the means if he has concluded that the suspect is guilty anyway. And this is the same Mark Fuhrman who says to Miss McKinney, and this is transcript 9, pages 11 and 12, Fuhrman, absolutely, let me put it to you this way. In almost 12 years on the department, I have never felt guilty one day, one split second. Miss McKinney, why? Fuhrman, because all those people out there deserve exactly what they get, and probably 20,000 times more. Miss McKinney, so you feel that you make judgment calls in a way that ensures those people to get what they deserve, and so therefore there is no reason for you to feel guilty about anything you do? And Fuhrman responds, well, yeah, it's the same thing. If you're in a rice paddy in Southeast Asia and a guy in black pajamas is running across a rice paddy with an AK-47, are you going to shoot him or wonder if he's really a communist or if he just stole those clothes from a VC soldier and he's running away? You shoot the son of a bitch and you don't worry about what he was. You don't worry what he could have been, just what he appeared to be, and that's good enough. Miss McKinney, at the moment, Fuhrman, you never know past the moment. There's a thing I've always said too. Even if you get the wrong guy, this guy's done something before, or he's thought about doing something. Now, Your Honor, we believe that in order to assess the credibility of Detective Fuhrman with respect to these issues in terms of his conduct on the morning of June 13th, this evidence must be considered. And you must ask the question whether you would believe this police officer in light of this evidence. And we believe that we're entitled to a finding for our appellate record of your conclusion with respect to the credibility of Detective Fuhrman. And we believe the most rational way for you to make that finding is for you to permit us to call Detective Fuhrman to the witness stand as part of this renewed motion to suppress and engage the most powerful engine that we have to expose the truth, and that is to cross-examine him and confront him with his prior statements to Miss McKinney.
Thank you, counsel. Ms. Lewis.
Your Honor, first of all, I want to define for the court what the court's role is. First, let's recall that Detective Fuhrman was, and I say let's recall because the court heard a prior 995 with regard to the motion to suppress that was heard in the court below. So the court's already read that transcript of that earlier motion to suppress. Detective Fuhrman was one of two police officers, the other being Detective Van Adder, who testified in the municipal court at that motion to suppress. And that is the factual context in terms of what motion we're talking about that this court looks at. When it came to the litigation of the search warrant, that was done before this court. Detective Philip Van Adder was the affiant on that warrant. His affidavit is what the court looked at to determine the validity of the warrant. Under the law, the court was restricted to, at that point in time, and never had to go beyond that, to the four corners of the affidavit of Detective Philip Van Adder. So when we're talking about Detective Fuhrman's testimony regarding motions to suppress, we are talking only about the testimony that he gave at the motion to suppress, the entry onto Rockingham, brought before the magistrate in the municipal court. Now, as I indicated, when this court reviews newly discovered evidence, and the court has already earlier indicated a finding, and I don't think we're conceding that it's newly discovered evidence. But when the court reviews newly discovered evidence, the court looks to the standard enunciated in the Bishop case, which is briefed in length in our brief on this issue, which is spelled out in length. And the Bishop case mentions several standards in there. What the court does not do is to decide the issue of Detective Fuhrman's credibility. What the court does do is to look to see whether the newly discovered evidence would have affected the finding of the magistrate below. The Ramsey case that counsel cited to the court includes that standard in a footnote where it says this court, Your Honor, can consider the evidence with regard to Detective Fuhrman in a de novo manner only if you determine that that evidence would have affected the magistrate's ruling below. Then you go on to this step, and that's that footnote, dicta in footnote in that case mentions that. But the standard is spelled out very clearly and at great length in the Bishop case. The court was trying to determine what standard to look at to determine when something is affected by, to try and give the trial court's guidance in this area. And the court looked at the idea of relevance. Well, what if it's relevant testimony, relevant evidence? Does that mean it would have affected the standard? And the Bishop court held it couldn't, because that hair trigger type of standard would automatically cause every magistrate's ruling in every motion to suppress brought in the lower court to be affected if mere relevance was the standard. And the whole idea of the legislature in changing this legislation back in 1986, I believe it was to provide the defense one opportunity for de novo review, and only one opportunity, except under very narrow circumstances. And this is one of the potential exceptions that applies when there's newly discovered evidence. But because of the policy of the law to maintain the finality of litigation, the Bishop court holds that there has to be a heightened standard under this situation. And the Bishop court, as this court has noted in a previous hearing, I think it's been many months ago now, looked to the area of new trial motions, looked at the law in that area, and the area of newly discovered evidence, and to see if that standard would be an appropriate one. And it held that that would be an appropriate standard. And I'm going to get back to the new trial motion a little bit later. But I do want to mention, Your Honor, this newly discovered evidence consists of statements that only go in some general manner to bias and credibility, nothing specific in this case, not to any specific person in this case, not to any specific observations or conduct in this case. It only goes somehow generally, in a general manner, to credibility. That, by definition, is collateral evidence. It's collateral evidence on credibility. It's not evidence that has any kind of direct inconsistent statement or direct impeachment of any officer, either of the two officers' testimony in municipal court. And the context in which now let's look at the evidence itself. first of all, we know that it's collateral just by definition because it doesn't have anything to do directly with what was testified to in municipal court. It's only very indirect and by inference upon inference. And then when you look at what the statements are, they're statements that Detective Fuhrman made to a screenwriter. And in that context, and I'm not saying that he was role-playing when he said them. What I am saying is that he was there to impress this woman to write a Hollywood movie. And we all know that Hollywood movies, particularly when they portray bad cops, are vicious, violent, horrible, and depict disgusting things. I mean, that's the whole purpose of a Hollywood movie, particularly when it's depicting bad police officers. You know, you can think of Richard Gere in Internal Affairs went around murdering people. That's Hollywood. That's what it's about. So these statements that he made to Laura McKinney, he was there to impress. There is no trustworthiness whatsoever that anything he actually said is something that he would do, even back then, or that he would do years later after he said those things to her in that context, in this case. So you look at the statements and they're not trustworthy. They're not said in a context that makes them at all trustworthy in terms of his actual state of mind of what he would do 8 years later when it comes to the investigation of this case, during which he played a very narrow role. So you're looking at not only collateral evidence, but evidence that on its face is not trustworthy and probative of even what it would purport to prove or what the defense would have it prove. So when you look at that farly removed evidence in terms of directly rejecting anything testified in municipal court, it becomes self-evident that its probative value is virtually nil. There's almost no probative value there. Now, one of the things the Bishop Court held, and I noticed counsel's lack of addressing the Bishop Court, though it does address this specific issue on newly discovered evidence and a renewed motion to suppress at length. One of the things that court held, the Court of Appeal, is that the implied credibility findings made by the magistrate below had to be affected by the new evidence as to both officers who testified. And here that means not only Detective Fuhrman, but Detective Van Adder as well. It's a heightened burden, and that's the language used by the Bishop Court, a heightened burden because this evidence regarding credibility would have to go to both officers. And this evidence, these McKinney tapes and transcripts and anything said by Mark Fuhrman has nothing to do with Detective Philip Van Adder and never has had anything to do with him. He didn't even know Mark Fuhrman before they met that night. So the defense has offered nothing to impeach either directly, indirectly, collaterally, in any manner the testimony that was given by Detective Van Adder extensively during that early motion to suppress, which entirely corroborates every important piece of information testified to by Detective Fuhrman. Detective Van Adder testified to the same things, or to things right in that same nature. I don't mean to say their testimony was identical, but he also testified to the important aspects that were under consideration for that magistrate to consider in that motion to suppress. Now, when you get back to the new trial, the standard of newly discovered evidence, newly discovered witnesses in the context of a motion for new trial, one of what I consider the Bibles in the criminal law is Witkin and Epstein. And Witkin and Epstein say that new evidence calculated merely to discredit a witness at the trial is considered of slight importance, and it is frequently said that it will not support a motion for new trial. So it is rare under the case law that a newly discovered evidence which goes only to credibility is given any kind of deference, and such that a new trial motion is granted. And that's the standard that the Bishop Court of Appeal tells us to look at in whether the court should hold whether or not evidence has affected the magistrate's ruling below in the motion to suppress there. And in fact, in a case cited in my brief in People versus Green, a witness was discovered, newly discovered, who would have impeached the prosecution's main witness, a police officer, regarding that witness's testimony as to the number of investigations he had engaged in and whether he made narcotics arrests for amounts under a certain quantity. So it would have been direct impeachment of that police officer's testimony itself. And the Court of Appeal in People versus Green upheld the trial court's denial of the new trial motion, and held as a general rule, evidence which merely impeaches a witness is not significant enough to make a different result probable. So it's whether a different result was probable. That's the analogy they draw in the new trial motion context to whether it would affect the magistrate. And in different words, make a different result probable there, that the magistrate would have ruled differently. So the Court of Appeal in People v. Green recognized it wouldn't have even made a different result there where it was direct impeachment testimony, let alone here where we have several steps by inferences removed, untrustworthy, but at best collateral impeachment in the terms of affecting credibility impeachment testimony. Now, we also know in this particular case, the magistrate below specifically told Mr. Shapiro when he tried to introduce collateral matter to discredit a witness, she specifically said, the way I see it, Mr. Shapiro, is that if in fact there is an inconsistent statement with something, with regard to something that the detective testified to during the course of the proceeding, then that would be admissible. But we're not going to create straw men to shoot down later that were not part of the testimony. So this own magistrate, to the extent that there's any, and I'm not sure it's appropriate, but if it is appropriate to look at this magistrate's state of mind and whether this particular magistrate's ruling would have been affected, it's pretty clear from that observation of hers that she might have admitted directly impeaching testimony and probably would have admitted directly impeaching testimony, but would not admit collaterally impeaching or collateral evidence regarding credibility. As the Bishop Court itself said, evidence which does not affirmatively prove an issue, but is used only to impeach or contradict an opposing witness, tends to impress weakly. And that's what that Bishop Court itself said with regard to whether it would have affected the magistrate's ruling below in that case. Finally, Your Honor, I want to point out that the people's burden at that motion to suppress was by a preponderance of the evidence. And we had the corroborated testimony of two detectives who testified in detail. All the defenses presented to this court here in terms of newly discovered evidence goes to, as I've mentioned, collateral impeachment, collateral credibility attack on only one of those officers. Now, I submit, Your Honor, that as a matter of law, that is simply not enough to, quote, legally affect the magistrate's ruling, and that is a term of art, so that there's no confusion, and that's what the Bishop Court has tried to define as a term of art. So there's simply insufficient evidence to show this newly discovered evidence would have affected her ruling because it is collateral and removed from the one officer who it even affects at all in terms of his testimony. It has nothing to do with the other officer. So, Your Honor, the defense is not entitled to yet another hearing in this court of any nature other than the legal argument we've just engaged in, because I believe the appropriate and proper ruling for this court to make is that this evidence would not have, quote, affected, as that term is used in the law, the ruling of the magistrate below.
Do you think, though, that the magistrate would have been interested in hearing cross-examination of Detective Fuhrman being confronted with some of this material on the tapes?
No, Your Honor, I don't. And in fact, I would like to respectfully remind the court, our courts of appeal and Supreme Court, most recently there's a case of People versus Superior Court Piedrahita, Piedrahita, 1995 at 34 Calap 4th 508, that repeats, generally speaking, the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. The cross-examination of the witness is always subject to a trial court's broad discretion to impose reasonable limits to prevent interrogation based on concerns, among other things, harassment, prejudice, confusion of the issues, and that would have happened here, or an interrogation that is repetitive or only marginally relevant. So the courts have wide discretion. There's also People versus Cooper, who also cites Davis versus Alaska, which is one of the defense attorney's favorite cases, it seems, to repeat that the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. Most courts, and particularly municipal courts hearing these motions to suppress, along with their preliminary hearings, day in and day out, are not interested in letting the defense go far afield into the netherland in cross-examining witnesses. They want to hear evidence that directly pertains to that witness's testimony and that is relevant and directly relevant to that witness's testimony. So by all indications, this particular magistrate would not have even allowed cross-examination on this issue, let alone have been affected by it.
All right. Thank you, counsel. I'm sorry, Ms. Lewis, do you want to address one other issue the request at this point to recall based upon this newly discovered evidence, which you concede the tapes are newly discovered since this discovery occurred subsequent to the preliminary hearing and the original 1538.5 motion. What is your position on at least the the defense ability to recall Detective Fuhrman as a witness to confront him with some of these things?
Your Honor, the defense has no such right. This is highly, as I've just argued and pointed out to court, this is highly collateral evidence. Their right was to present to this court the newly discovered evidence. They've done that. This court has read all of the transcripts, I'm sure listened to all of the tapes. I know it's listened to all the tapes, made a detailed, lengthy ruling with regard to the 60-whatever proffers. So this court has heard and has taken in that evidence. It's in the record. It's there. And the defense has no right. And, in fact, it would be inappropriate, I believe, for this court to get into any kind of factual determination, which it would be doing if it attempted to hear testimony from Detective Fuhrman. May I have just a moment, Your Honor? As Ms. Clark points out, the statute does not allow for, or does not say that they have the right to confront and cross-examine any witness with regard to this newly discovered evidence. And this is a situation where it's clear, Your Honor, the magistrate below would not have allowed, and as much as I can read her mind, but, you know, having worked in these Muni courts for many years, and this court knows what it's like in Muni courts with the number of felonies prosecuted by this office and the number of witnesses that are called daily, and 10 to 15 prelims a day is not unusual downtown. I mean, not only as a legal matter, but in terms of the exercise of these magistrates' discretion, it's very easy to predict that she would have not, because no magistrate below in a municipal court in this building or in any other building, probably in L.A. County, would allow the kind of cross-examination the defense seeks to bring on at this point for this court to hear. But I didn't mean to get sidetracked. No, they do not have a right to recall Detective Fuhrman to confront him with this, and it would be inappropriate to do so. The court has the information that it needs, having heard the transcripts and listened to the tapes, to determine if, indeed, that was even admitted by the magistrate below, which I submit it wouldn't have been. That would have had the legal effect of affecting her prior ruling and causing her to grant the motion. And it simply could not have had that effect when you're talking about two police officers testifying where that evidence affects only one. And the Bishop Court holds that the defense has a heightened burden of it affecting both officers' testimony.
Thank you. Mr. Uelmen?
Your Honor, having had the benefit of participating in the determination by the magistrate of the motion to suppress in the municipal court, I can assure Your Honor it was not one of 15 or 20 motions being heard on a routine basis. We're talking about a preliminary hearing that went on for more than a week. We are talking about a magistrate who told us how troubled she was by the issues raised in the motion to suppress, and who made some very careful findings which were largely dependent on the credibility of the testifying officers. That is, she believed the reasons that they offered to justify the actions that they took, and she believed they were reasonable under the circumstances without having the benefit of knowing. What's the matter? Is my zipper open?
No, I was just noticing one of our CCB residents crawling on the table there.
All right.
Never mind.
Should I kill it?
Got it. Women do kill roaches, Your Honor.
Sorry about that.
The issue before Your Honor, however, is not what effect would this evidence have on the magistrate. And that's the whole point of the Ramsey decision. Where additional evidence is presented, the findings of the magistrate, to the extent they are affected by additional evidence, are not binding on the Superior Court. As the Ramsey Court put it, this allows the Superior Court to exercise its independent judgment on issues on which additional evidence is introduced. So we're not in the position of trying to go back and recreate how Judge Kennedy Powell would have reacted if she had had the opportunity of hearing the Fuhrman tapes in deciding whether she should believe Detective Fuhrman's account of what happened on the morning of June 13th. To the extent that this is newly discovered evidence, the question is, what finding does Your Honor make about the credibility of Detective Fuhrman with respect to the events that took place on the morning of June 13th? And to that extent, the Bishop case relied on by the prosecution is in opposite. They're saying you must challenge the credibility of both officers, but that occurs in a context where the two officers corroborate each other, where you have two officers testifying to the same thing. Of course, just attacking the credibility of one officer isn't going to undercut the factual finding. But with respect to each of the factual issues we have identified, the discovery of the speck on the door of the Bronco, the investigative activity in terms of searching for evidence that took place in the room of Cato Kalin, the searching activity that took place behind the house after Detective Fuhrman decided to follow up on what Kalin told him. Every one of these were judgments or discoveries made by Detective Fuhrman without any corroboration. He was by himself. He was alone. And his credibility stands alone with respect to each of those issues. We're not asking to relitigate everything here. Of course, we're not seeking a hearing de novo on the search made pursuant to the warrant, only to the extent that if the evidence found in the warrantless search supplies the probable cause for the issuance of the warrant, then of course the evidence discovered pursuant to the warrant would also have to be suppressed. But what we're talking about here is a warrantless entry to premises. We are talking about the credibility of the decisions and the judgments made by Detective Mark Fuhrman acting alone, and we are asking, what confidence can you have in his credibility with respect to that action that he took, knowing what you now know from the Fuhrman tapes? And the Fuhrman tapes, Your Honor, is in a very good position to make a judgment about whether he was just impressing a screenwriter. We believe the tapes clearly demonstrate he was expressing his own attitudes, he was expressing his own opinions, he was describing his own practices. And those are certainly relevant areas to cross-examine him on before we make a determination of his credibility. And that's an opportunity that was deprived to the defendant because this evidence was not available at the time Detective Fuhrman was confronted in the municipal court. And bear in mind that when Detective Mark Fuhrman testified in the municipal court, he was there to impress a judge. Just as counsel suggests, he was there to impress Ms. McKinney. And the issue that we have to address is whether that was a false impression, whether the conclusions that we draw with respect to the credibility of this witness, of this key witness on this issue, of the suppression of the evidence, can be trusted in light of this newly discovered evidence.
Mr. Uelmen, let me ask you this, though. What would calling Detective Fuhrman add to the court's record in evaluating the credibility issues that you raise, given the fact that the tapes that the court heard are Detective Fuhrman's voice? I mean, the foundation has been laid either through Ms. McKinney through the 402 hearing or during the course of the trial. We've established that, that is in fact Detective Fuhrman's voice and his statements. Is there anything to be served by calling Detective Fuhrman? What else would you add? Did you say this? Is this your voice? I mean, I can think of 2 or 3 questions we might ask Detective Fuhrman, but...
Well, credibility determinations are based on the entire galaxy of the demeanor of the witness, the factual accuracy of his account. We believe that everything we have pointed to in the Fuhrman tapes goes directly to issues that he talked about in his testimony and that raised questions about what he was saying.
Well, what would be your offer at this point, given the fact that the court has, with regards to previous rulings, reviewed the transcript of the preliminary hearing? With regards to prior motions regarding the McKinney matters, the court has read the transcripts, listened to the tapes. I did sit through, my recollection, it was approximately 5 or 6 days of testimony by Detective Fuhrman during the course of this trial. What more can we add to the record? What more do you think would be needed to add to the record for the court at this point to evaluate all these things anew? And I agree with the point that you make, that based upon the showing of newly discovered evidence, which was not available, not reasonably available at the time of the preliminary hearing, that the magistrate's finding is not binding upon this court, and that this court, upon appropriate motion which you've made, is required to go back and reassess what's here. But you're asking, in addition to that, asking to recall Detective Fuhrman, and I'm just asking for an offer of proof as to what line of questions you would venture into that would add to the court's store of knowledge with regards to Detective Fuhrman.
We would confront Detective Fuhrman with each of these key accounts or justifications that he offered for his conduct on the morning of June 13th, and we would question him as to whether on prior occasions he has indicated that he doesn't play by the rules, that he makes the rules up later, that he doesn't really care what the courts say about what officers can do and can't do.
In other words, you would go through each one of the 61 incidents that you put forth in your offer of proof with regards to the offer regarding Miss McKinney.
No, Your Honor. We've submitted a new offer of proof just related to this, which lays out, I believe, 7 excerpts from the transcript that we believe are relevant just to the issue of probable cause. We're not trying to open up racial attitudes. We're not trying to open up the whole spectrum of police misconduct that was raised in the McKinney motion. We've tried to focus this right on the issue of probable cause and justification for police conduct in which he engaged. And I know Your Honor has heard Detective Fuhrman testify, but I really would ask you whether you would hear his testimony with the same ears today, knowing what you have heard on those tapes. And
it's not just knowing what I know on those tapes, it's what I heard from Miss Singer, it's what I know from Miss Bell, and what I heard from Mr. Hodge.
And that, too, is all newly discovered evidence, Your Honor. The fact that Detective Fuhrman has perjured himself in this trial, we believe, is relevant to the credibility that we give to the testimony at the motion to suppress. I dare say that in any case being tried in these courtrooms, if in the course of the trial a court were convinced that an LAPD officer had come into the courtroom and committed perjury, the court would not hesitate to go back and reevaluate and re-examine the testimony that was presented in the pretrial motions. In fact, we have inquiries going on right now where on the basis of the discovery of forged evidence, we're going back to cases that were tried years ago to get to the bottom of it, to get to the truth of it. And that's precisely what we propose to do here.
All right, given that offer, what do you think the likelihood is that Detective Fuhrman would be, former Detective Fuhrman would be available to testify?
There's only one way to find out, Your Honor. Let's bring him in, put him on the witness stand, and put the questions to him.
All right, thank you, Counsel.
Could I have just a moment?
Sure.
May I? Oh,
Why don't you
sorry.
wait until Mr. Uelmen finishes talking to Mr. Neufeld.
I'm in debt to Mr. Neufeld. To the extent that the people are arguing that there is any question about the context of what is said in those tapes, that is, whether he is speaking his own mind, whether he is puffing, whether he's trying to impress Miss McKinney, the way to determine that is by questioning and cross-examining him.
All right, Ms. Lewis.
Your Honor, the concern here, of course, is that Detective Fuhrman is not himself in the same position that he was down at the municipal court below. There was no, there had been no testimony with regard to the N-word. There had been, that's totally irrelevant to this proceeding, this hearing. But Detective Fuhrman now finds himself in a position because of that. And because of the, it's clear there's been an outcry in the city, Your Honor, and perhaps appropriately so. But as we've stressed over and over again, that is for another forum, another place, another time. To box this court in to calling Detective Fuhrman, making him have to make the difficult decision of whether or not to take the Fifth Amendment, creates additional complexity and adds issues and misleads. Well, it doesn't mislead, but it consumes time, takes away from the sequestered jury we have in this case, adds nothing to this court's knowledge with regard to what it needs to know to determine if this evidence would have affected the prior magistrate's ruling. It does not, it is certainly within the court's discretion to deny any such motion, and I think as a matter of law it's inappropriate to even entertain such a motion by the defense. And in addition, as Ms. Clark points out, even if it were true that that's how he felt back in 1985, there's no proof that that's how he feels now or felt in 1994. You know, this was a man who, well, I don't want to get into the history. The court, heard evidence in context of the Pitchess motion, but people change over time. This man became married, had 2 children. You know, I don't want to get here into a personal defense of Mark Fuhrman. That's not why I'm here, Your Honor, and I don't want to do that. What I do want to do is point out to the court that this is collateral evidence that does not go to directly impeach him and that there are 2 officers who testified. And for this court to get sidetracked off into a side issue of whether Mark Fuhrman is going to take the Fifth Amendment is not appropriate, not in this context especially, when we're talking about the renewal of their motion to suppress. The court, as it's just explained, has all of the evidence it needs. It has its very complete, there's no such thing as jury. The record is complete, and that means one thing. It is complete in terms of what this court needs to assess whether or not it would have affected the ruling of the magistrate below under the circumstances of that case. And this court is not, I submit, entitled to this defense argument of the perjury, whether or not perjury was committed here in this case, in assessing whether it would have affected the magistrate below. And, Your Honor, whether the defense offers 7 excerpts from their new proffer or the 60 or 70 that they offered below, the law is the same in this regard. The court has heard all of those. The court has read the ones that, all of them, plus the ones that were not available to hear on tape. So the court already is intimately familiar with it. It's time for the court to have to make the difficult decision and to have to struggle with making a ruling on this case. But that's not going to be, that burden is not going to be lightened and would just be dragged out, and likely the court's, the complexity of the ruling would be magnified by having additional unknown factor thrown in at this point in time, Your Honor.
But if I don't do that, don't I have an incomplete record?
Oh, absolutely not, Your Honor. Please. I mean, the court conceded this is collateral evidence. It does not and never had to allow cross-examination on this evidence at all. The defense in the new proffer is talking about misconduct things. They recognize it's apparently, because they left it out. They don't even leave out the N-word stuff. I mean, the court has heard all this stuff. The court has heard the context in which it was played. The court, and in fact, if Detective Fuhrman gets up here and takes the Fifth, the court, I think the state of the law would be the court cannot consider him having taken the Fifth in terms of deciding the earlier ruling, because the jury is not allowed to hear that somebody took the Fifth, and I'm sure the same law would apply, that the court could not consider that fact because you'd be impinging on his right against self-incrimination. It gets unduly complicated, Your Honor, and it's not necessary. The record is complete. I know you as a very thorough, meticulously thorough judge, but I'm telling you, Your Honor, as a meticulous and thorough attorney, this record is complete on this issue.
All right, thank you, counsel. Mr. Mounger, Mr. Darryl Mounger is also here with us. counsel for Mr. Fuhrman. Good afternoon, counsel.
Good afternoon, Your Honor.
You've been present for our discussion regarding the defense motion to, based upon newly discovered evidence, to revisit the motion to suppress. And one of the key issues is whether or not the court would allow your client to be recalled as a witness for additional testimony. Do you have any observations regarding that?
Well, before I answer that question, may I be allowed to speak briefly about the motion?
Well, I think the issue is whether or not your client is available to testify.
Well, Your Honor, first I would ask that, similar to the issue when Mr. Kardashian was asked to be a witness, because of the position that Detective Fuhrman is in, I would first like to see, if the court could allow it, the questions, the exact questions that they plan on asking him, because asking him to testify at this point in time may have a difference depending upon the questions that are asked.
All right, Mr. Uelmen, do you have an additional copy of your specific offer proof regarding this issue available?
I'm sure we can have a copy duplicated, but we don't believe a witness is entitled to a preview of the questions that they're going to be asked on cross-examination. The whole purpose of cross-examination is to test the credibility of the witness in reacting to questions as they are put.
Well,
Certainly,
at this point, counsel, since, I mean, that offer of proof is not under seal, it's not exactly a mystery as to what it is we're talking about here. We've discussed it here in open court just now.
yes. Well, I'm sure we can simply duplicate the copy we have available.
All right. Well, in any event, I need to give the court reporter a brief recess, so we'll take a brief recess. Counsel, if you'll provide Mr. Mounger with a copy of that, he can peruse that, and we'll discuss it, continue this discussion in about 15 or 20 minutes.
Thank you, Your Honor.
All right. Thank you, counsel.
Please clear the courtroom.
Where did Mr. Shapiro and Mr. Cochran disappear to?
That's what we need.
All right, back on the record in the Simpson matter. All parties are again present, including counsel Kent Spaulding. Court has acted upon the application pro hoc vice and approved that. Good afternoon, counsel. All right. During the brief recess, counsel had the opportunity to informally discuss scheduling matters, and based upon the Brady issue that the court still needs to deal with this afternoon. Mr. Cochran.
I had indicated to the court that with regard to the Brady, Messrs. Scheck and Shapiro, along with Ms. Sean Snyder-Chapman, will be down at 4 o'clock. They're in the process of interviewing witnesses. They did indicate to me that they may not be ready to proceed completely today on that, and may ask to start that tomorrow morning. And I told them to come by 4 o'clock so they could let the court know that. That's the only holdup that what we talked about earlier.
All right, and I see Mr. Mounger stepped out briefly.
Your Honor, may I take this opportunity very briefly just to mention something that I neglected? It's my fault. I neglected to mention to the court earlier.
No, I don't think so, Ms. Lewis. You've filed your points and authorities. I've heard rather
There was
extensive argument.
a supplemental memorandum filed by the defense yesterday afternoon after they'd already filed their two other memos in the same thing that I did not pay careful attention to, so just briefly for the record, please. Please, I can see we have time. We're waiting for Mr. Mounger. Very quickly. Very quickly. It might help the
The
court in this
moment he
ruling.
walks in the door.
Thank you, Your Honor. First of all, on page number 4 of their defense...
But then I have to listen to Mr. Uelmen as well.
Okay. Offer of proof of newly discovered evidence for motion to suppress. They have three things, very briefly, Your Honor. The first thing is that they say the decision to make entry by climbing the wall. Detective Fuhrman was the D2. We know that the others out there were all D3s.
Counsel, I recollect the testimony.
I'm sure it was their decision. The second offer had to do with Mark Fuhrman searching Cato's room, but their cross-examination of Mark Fuhrman would add nothing to Mark Fuhrman's credibility on that because Cato testified at the preliminary hearing during the motion to suppress and testified to the thumbs.
He gave consent to the search. Next
Yes,
question.
and also indicating the thumps on the wall. So that makes Detective Fuhrman's testimony that Cato told him he did thumps on the wall. I mean, there's no credibility issue there whatsoever. And the third one was that given the statements that Cato made to Detective Fuhrman, which we know were made, that was obviously why Detective Fuhrman went behind the walkway. So how is the defense going to hurt his credibility in terms of why he went to the walkway when we know Cato testified during the preliminary hearing as to those three thumps behind there? That's all I wanted to say, Your Honor. I just wanted to point out that their intended cross-examination would not shed light on the issues they list in this supplemental brief.
All right. Thank you, counsel. Mr. Uelmen, do you feel compelled to respond to that?
No, Your Honor.
All right. Thank you. All right, we've been rejoined now by Counsel Darryl Mounger, who represents Mark Fuhrman. Good afternoon again, Counsel.
Your Honor, over the break, I talked to Mr. Fuhrman, and it is our position that because I am walking into this trial after 8 months, I am unfamiliar with all of the testimony. I have been handling my own cases and not followed this trial intimately. I have come into this court asking for the McKinney tapes and a copy of the transcript so that I might review them with my client. Although I have reviewed most of them, I have tried to correlate that information and interview my client, and I'm unable to put it in the context which it deserves. Based upon this court's August 31st ruling, and the words specifically, I believe, on page 5, on the information I do know and the information especially I do not know, I have advised Mr. Fuhrman that he should not answer any questions before this court. Therefore, it is my understanding that he will assert his Fifth Amendment privilege if asked any questions.
All right. Mr. Uelmen, for the purposes of the record, will you accept that representation?
No, Your Honor. We believe it's necessary for him to assert the privilege from the witness stand in response to a question.
All right. Since there's an unwillingness to accept and stipulate to that, it'll be necessary for Mr. Fuhrman to resume the witness stand for the purpose of this motion and to assert the privilege.
He will be here shortly, Your Honor.
All right. All right. Then, Mr. Uelmen, Ms. Lewis, I've indicated to you off the record that I need to, in order to rule on the motion to suppress, the renewed motion to suppress, I need to review the preliminary hearing transcript, which I have not had the opportunity to do since much earlier in the trial. So I'll need to do that. So I don't think you should anticipate a ruling this afternoon on that motion. And Mr. Cochran, I did see Miss Chapman come in. There she is. Did she give you a status report?
I'm informed by Mr. Scheck and Ms. Sean Snyder-Chapman that they're in the process of interviewing witnesses, that they will take the rest of the day to try and do that. They cannot finish, they think, until tomorrow morning in that regard. They're asking that we come back tomorrow at 10 o'clock and they'll be ready to proceed with the Brady motion. They're going to have these witnesses brought down shortly with Mr. Shapiro, I believe, along with Mr. Yokelson, to ask that they be ordered back, to finish today and then ordered back for tomorrow morning. It's my understanding of what Mr. Scheck has indicated. And we would start again at 8:30 tomorrow morning after they finish today.
I'm sorry, I heard 8:30 and I heard 10 o'clock.
Yeah, 8:30. They're going to try to finish the interviewing the witnesses this afternoon. In case they can't, they want to resume the interview tomorrow morning at 8:30. And they say, given that,
How about we finish the interviews tonight and start tomorrow morning at our regular 9 o'clock?
I'm sure they're going to try to do that, Your Honor, but out of an abundance of precaution, their thought was there are a number of witnesses. They would perhaps need until 10 and have the witnesses ordered back tomorrow for 8:30. I think that was the plan. They are trying, Your Honor. We had them go do that this afternoon.
How many witnesses are we?
Let me let one of them speak, Your Honor.
All right, Ms. Chapman.
Good afternoon, Your Honor.
Good afternoon.
I know that Officer Detective Maxwell was going to leave by 4 o'clock today to try to pick up a child from school. So I don't know that we'll be able to interview him this evening. Mr. Yokelson will be down with the rest of the witnesses, and we'll try to interview whomever we can this afternoon.
But how about if we come back at 9 o'clock, and if we then at that point can't?
Okay. Okay.
All right. Thank you.
So the record is clear. The defense has had 6 months to talk to these people. They interviewed Lucianne Coleman
Excuse me,
in
counsel?
April.
Ms. Clark.
They interviewed Ms. Coleman in April. That means that as of this date, we have more than 4 months that they have had to talk to these witnesses, and now we need extra time at the 11th hour for them to interview witnesses they've had access to, opportunity to talk to ad nauseum for more than 4 months, and in some instances 6 months.
Which is why I'm inclined to resume tomorrow morning at 9 o'clock at our regular time. There are other motions we do need to conclude, however, at this point in time.
And can we get a representation on the record as to what other witnesses the defense intends to call, other than the Brady witnesses, quote unquote, and I use the term loosely, that they intend to call before the jury?
I think part depends on the court's ruling on the 1538.
How would that be? Assume the court grants it. What further witnesses would they need to call?
I don't know. I don't ask. Mr. Cochran, who else do you have after, since we've finished Mr. Hodge and the court's ruling, we're finished with Ms. McKinney?
Part of it is, Your Honor, that there are 2 witnesses, as the court is aware, that I mentioned Mr. Vetrano and Mr. Goldston, who are upstairs. I presume they're going to be talked to. I haven't gotten a report on those 2 at this point. We would also like, so we don't have any downtime, I've indicated this to counsel earlier, to know who their first rebuttal witnesses are so we can prepare for those. Otherwise, we have downtime on that also.
All right, so your representation is Goulston and Vetrano based upon the interviews that you conduct this afternoon.
And Fuhrman, if the court is aware of that, and then plus the Brady motion.
All right. All right, thank you, counsel.
Thank you. We're going to need the rebuttal witnesses also, Your Honor.
As soon as the defense rests.
All right, Mr. Uelmen, I take it at this point then you wish to recall Detective Fuhrman?
Yes, Your Honor.
All right, and so the record is clear. My recollection is that Detective Fuhrman, who is now present in court with counsel, Mr. Mounger, my recollection is that Detective Fuhrman was excused but not released and was subject to recall. Is that your recollection?
That is correct, Your Honor.
All right.
He was not excused. It was-
Well, let me rephrase that. Subject to recall, excused for the day, subject to recall, not terminated as a witness before the court.
That's correct.
All right. All right, and Mr. Mounger, if you wish to stand next to your client, you may. All right, Detective Fuhrman, would you resume the witness stand, please? All right, good afternoon, Detective.
Good afternoon, Your Honor.
You're reminded, sir, that you were still under oath. Mr. Uelmen, you may proceed.
Detective Fuhrman, was the testimony that you gave at the preliminary hearing in this case completely truthful?
I wish to assert my Fifth Amendment privilege.
Have you ever falsified a police report?
I wish to assert my Fifth Amendment privilege.
Is it your intention to assert your Fifth Amendment privilege with respect to all questions that I ask you?
Yes.
Could I have a moment?
Certainly.
Your Honor, further questions don't serve any purpose since my client has already answered that he will not answer any question and will assert his Fifth Amendment privilege. Anything further can only be a show.
I only have one other question, Your Honor.
What was that, Mr. Uelmen?
Detective Fuhrman, did you plant or manufacture any evidence in this case?
I assert my Fifth Amendment privilege.
All right, based upon the witness's answers, the representation by his counsel, Mr. Mounger.
Your Honor, people make an objection to the last question asked the court to strike it as being improper and done for nothing but headlines.
Or will, the answer will stand. All right. Ms. Clark, do you have any questions of this witness?
No question.
All right. Then, given the assertion of the Fifth Amendment privilege, we will not conduct any further inquiry as to Detective Fuhrman. But, however, Detective, I am going to release you from further attendance this afternoon. However, you are still subject to recall. All right. Thank you, sir.
Thank you, Your Honor.
If the defense intends to recall Detective Fuhrman for the purpose of having him assert the Fifth again, I suggest that we do it now. Why have him come back for that purpose? They're not permitted to do it in the presence of the jury.
No, counsel, I just want to make sure we preserve the jurisdiction of the court in case there are any other issues that come up.
I
That's
understand that, but what I'm saying is, will this assertion suffice for the trial testimony as well? I can see no purpose to be served other than a further waste of time to have Detective Fuhrman recalled to reassert the Fifth Amendment privilege again. And I'm asking that if counsel intends to do so, that we allow that record to be made at this time
that record's been made at this point.
for the purpose of trial testimony as well.
Based upon the representations of counsel that he's not going to answer any further questions regarding this case.
Your Honor, since he lives without the state, is he free to travel home?
He's-
May we, have the court approach, allow us to approach him?
Sure. All right, with Mr. Mounger, please.
who is in court, Detective Andrew Purdy, who is present with his counsel. We'd like him back for tomorrow.
All right, counsel, your name for the record?
William J. Haddon, Your Honor.
All right. Mr. Haddon, you and Mr. Purdy ordered back tomorrow morning, 8:30.
Thank you, Your Honor.
All right, thank you. You're excused.
Your Honor, we have 3 members of the District Attorney's Office we'd like to have for testimony tomorrow that we've informed Mr. Hodgman of. We need not give their names tonight. And we have several other officers that Mr. Hodgman has been kind enough to accommodate us with, but we have not had time to interview. And we would like to give you that list, but not in open court. We have no other witnesses in court. Is that correct, Mr. Hodgman?
Yes.
Well, we would like to give you that list to Mr. Hodgman.
All right, what's your
I'm sure we'll
time
make
estimate for your Brady motion?
Your Honor, we are still in the process of interviewing some of the witnesses. Mr. Purdy has been very, very cooperative. We have about another half hour with him, and we'd like to interview the remainder of the witnesses tonight. I'd be in a better position to give you that estimate tomorrow morning when Mr. Scheck, Ms. Chapman, and I have had a chance to assimilate all the material.
All right. So what advice do you give the court on the question that weighs most heavily on my mind?
I would say that certainly no earlier than 10 o'clock, Your Honor. I think by that time...
I'm getting advice. All right, Ms. Clark, what's your position?
I think I made it pretty clear. They've had 6 months to talk to these people, and now they want more time. This is another delay with this jury on ice again that's so unnecessary. And has the court pondered?
No, I'm just asking, do you have any estimate as to how long you think the hearing will take based upon what you know from the moving papers, who the witnesses are, and what the issues are posed? I mean, do you just have a guess? I'm just inviting you to help me a little so we can not keep the jurors too inconvenienced for too long.
Well, there's no testimony necessary on the motion, Your Honor. Counsel can make their pitch to the court. The bottom line issue of this, I think, comes back to what the defense likes to characterize as a log, and that's of Officer Purdy, and that's it. There is very little else to talk about, but it certainly does not require the testimony of witnesses. And if this hearing is conducted in that fashion, which is all that is required, then it should be done in about half an hour. Because there is no exculpatory information that has not been turned over, Judge. You know, the people in this matter turned over everything that came to them back in February, as the court knows, submitted it to the court for examination, for IAD investigation, all of which was turned over to the court back in February of this year. So at this point, you know, the people have satisfied their obligations. There's nothing that we haven't done. And the court should be able to make that finding in about 2 minutes.
All right, I'll guess an hour then.
Yeah.
For the court's edification, ordinarily, the facts would not be in dispute when we're dealing with deputy district attorneys and members of the Los Angeles Police Department. However, we're in a paradoxical situation here where we have certain statements, and one under penalty of a declaration that's been filed that has not been signed, that indicates a certain set of facts from at least one and possibly 2 deputy district attorneys, and a statement that we understand was given under oath in internal affairs saying that the deputy district attorney was a liar from one of the members of the Los Angeles Police Department. If we could get a resolution of the facts with the help of the district attorney's office, that would certainly move this proceeding along.
All right, thank you.
May I remind the court that it asked counsel to bring in their reports and notes to assist the court in determining what stage they were at, and I think the court asked them to do it last week. Was that turned over?
Yes. Yes, it was.
The people have
All right.
not been furnished with any of that.
10 o'clock
Thank you.
with the jury. All right, anything else? All right, we're in recess.